Nate here. Welcome to the live stream. I'm usually behind the computer making sure your comments come through as you ask them so that the lawyers can talk about them. Before we hop into the live stream, I just want to let you know of something that is really cool that we offer completely free. It's a physical version of a book written by attorney Matthew Hill that talks you through the entire VA disability process from beginning to end. The link is going to be put in the comments right now by me, and it's also in the description. I highly recommend you click the link and claim your free book now. I cannot stress how much this is going to help you. So if your question isn't answered today, it could be answered in this book that we will mail to you completely for free. That being said, let's go ahead and get this live stream started. We're going to go through the questions in order as they come. And if we don't get to yours, we apologize, but maybe we'll be able to get to it in the coming weeks. Thank you so much for joining us. And now it's time for the lawyers to answer some questions.
Hi, good afternoon, and welcome to Hill and Ponton's live stream today. My name is Shelly Mark, and I am here with Kerry Baker, and we are going to do our very best to answer your questions today. And so let's get started. Nate, we are ready.
All right, this message is from Reginald McDuffie. If I'm butchering that, I apologize. I put in a claim for PTSD. I don't have a stressor on file because I got out shortly after. Will this be automatically denied, or what can I do? I'm already SC for anxiety. All right, so the important part there is you're already service connected for anxiety. PTSD and anxiety are rated together. They are not rated separately. So to answer your first question, yeah, it probably would be denied unless VA conceded to a stressor, since PTSD does need one. But at the same time, PTSD is an anxiety disorder. Rather than putting a claim in for PTSD, I would put a claim in for an increase in your anxiety rating, depending on what that is already. But it's kind of, I won't say an exercise in futility to put a claim in for PTSD when you're already service connected for a mental health condition. But if they grant it, they're still going to evaluate your overall mental health condition unless they could medically separate out the functional limitation caused by the anxiety from that caused by the PTSD, which is a next to impossible feat since they are almost literally one and the same in many respects. So Shelly, you got anything to add there?
No, I agree.
From an email earlier this week. Filed claim October 2022 and denied. Filed supplemental and denied. Higher level review awarded January 24. Service connected for the original date of 2022 at 30%, and rating increased for my HLR dated January 24. From my understanding, pending what my CMP exam notes state from the October 22 filed FOIA February 24, I should be able to submit a supplemental claim for service connection date.
Kerry, you want me to try that one?
Yeah, go for it.
Nate, will
I
you
think
go back to
it's
the
a good question.
original? I think it's an effective date question,
Yeah,
or so it looks like he filed a higher level review after the supplemental, and he was awarded the service connection in looks like January of 2024. Um, they increased it to January, or it looks like he got the 50% increase January 2024. I'm assuming that all came from the higher level review that was filed. The big picture answer is that if your symptoms were the same back in October of 2022, then that 50% rating should certainly go back to the date that you filed that claim. If that increased rating is coming off of the back of that higher level review, then you are correct that you will have to file like a supplemental. Unfortunately, you won't be able to do a higher level review again. You could file a supplemental with a statement stating that your symptoms hadn't changed and that you've been actively pursuing the claim since October of 2022. Um, Potentially, if there was a duty to assist error that was issued off of that higher level review that you filed, that would shift that higher level review into a supplemental appeal, and you would be able to submit a higher level review arguing that earlier effective date of the increased rating. I hope I didn't make that too confusing, but the answer is that you should be entitled to that higher rating back to when you filed it in October of 2022. And this is something that we see pretty regularly where they grant the increased rating, but the date's wrong, and you just have to push a little bit harder to get the date corrected.
Yeah, I'm going to add a little bit to that. A little bit of devil's advocate. I agree 100% with what Shelly said. I would want to know, what happened in January of 24 for the HLR reviewer to assign the 50% from then versus the original date of claim. I would assume there's some medical evidence showing it's worse at that point. Or maybe there was another VA exam on that date that showed it's worse. VA can do staged ratings when things over time have gotten worse. But at the same time, just like Shelly said, you're dealing with an effective date from the original claim, which is in 2022. So one, I would want to know why did they change it to 50% on that date? What's the evidence that they used? Two, you may, depending on what that evidence is, kind of how Shelly laid out your various options there. If there's nothing else to file, if in a supplemental, you may run into problems with a supplemental claim rater changing the effective date of a rating set by a DRO doing the HLR. Now, I'm just hypothetical. Your supplemental claim rater may grant the earlier effective date. But if not, you would probably need to go to the Board of Veterans Appeals in case, because we run into problems all the time where supplemental claim rater, they don't want to touch something that somebody above them has done. Even though they can in situations like that, sometimes they think they can't. So it could cause you problems. So be prepared to go to the board. I would do what Shelly said. And if it doesn't work, then I would take it to the board, asking for an earlier effective date. All right, happiness. I found in service medical evidence for hubby from 20 years ago describing his gout and foot eczema without an ICD. He has had 3 gout episodes this year. Could that be a nexus for both? Also, ankle bursitis separate rating or in with gout? With foot eczema being painful with open sores making it difficult to walk, would that be a higher rating if connected? So gout and ankle bursitis, it really depends on where the gout is, but it should be separate. The gout's on the foot and that's not quite the same as the ankle. That could be separate ratings there. As far as a nexus, can you go back to that first part, Nate? Found in service. I mean, gout. He had gout 20 years ago and he's got gout now. That may not be an automatic nexus, but that's pretty good evidence. What happened in that 20 years? Did he ever get a flare up of it? If they wouldn't grant it, I would think with a favorable medical opinion, I'm sure they would. As far as the ratings go, yeah, I would hope for a separate rating, but they get those wrong a lot. Shelly, you have anything else there?
No, I agree with you. I think that's definitely some evidence that I would be pointing out to them and getting that filed if it's in the service records.
Yeah. All right. Angel L. Morero. Greetings. Can I appeal my recent PACT Act decision letter using a supplemental 0995 for all of the following reasons? VA backpaid me using my intent to file date of May 3rd, 2023 instead of the PACT Act effective date, August 10th, 2022. Inadequate CMP exam, low ball ratings, correction of legacy code sheet. Should read combat number 2. Thank you. I wouldn't be so concerned with the code sheet unless you're going for CRCS or something. It's not going to change anything with VA. Yeah, it kind of depends. If those were all granted because of the PACT Act and they were PACT Act issues and they were filed within a year of the change in law, then yeah, you've got a valid reason there for an earlier effective date. If the ratings were low ball, yeah, you've got a valid reason there for an appeal. I don't know. That's Shelly.
Wait, will you skip back to the initial? So I just would take a look and make sure it says to file a sup. Just remember, if you're filing a supplemental appeal, that you're going to have to provide some new evidence. And if you filed a claim and they've awarded it, you think there's an issue with the effective date and the rating, and that evidence is already in the file, then you might be probably going to be a little bit better served to file a higher level review and argue on what's in the file, unless there's something you feel like you need to submit, and then you can do the supplemental. But I agree with Kerry that if you filed it within that time period after the PACT and it's related to PACT Act, then you can definitely appeal those issues.
Yeah, but keep in mind if it's if you file for a back condition or a knee condition that wasn't granted because of what they did in the PACT Act, you can call it a PACT Act claim all you want. It's not a PACT Act issue. Okay, so it really depends on what those issues are to get that particular effective date. But yeah, we've seen them mess those effective dates up. It should be a relatively easy fix, I would think. Mark had aloha. Thank you, Helen Pont, for advocating for veterans. Can you explain the 55-year-old rule for me and dumb it down for me like I'm a 6-year-old? Exceptions to the rule, other concerns, something in Hawaiian.
Mahalo? Is it mahalo?
I don't know.
The 55-year rule.
Yeah, that rule.
So that reminds me of Social Security, which we won't get into, but I don't know. Do you the 55-year rule?
Now, I've seen questions like this before. There is no 55-year-old rule. There may be some, and I'm going to take a leap here and assume that you may be asking about, say, future exams for disabilities.
Maybe.
Or unemployability, maybe not unemployability. Usually I've heard it asked in relation to future exams, like if somebody is 55 or older and they have a certain disability, VA is not going to re-examine them. And that may not be what you're referring to, but if that's what it is, that is no rule. Things that have progressed to certain points, depending on the disability, it may make common sense that one would assume it's not going to improve once you're that age, and therefore no reason to set up a future exam for it. But that doesn't work with all disabilities. If you got a temporary rating for active cancer or something that may go into remission, we've seen those regardless of age get examined in the future. If that's what you're referring to. But there's certainly no regulation. When you say rule, as typically we refer, it's interchangeable with rule, regulation, all the same thing. So an actual law concerning people that are 55 years old. If your question is regarding pension or something, I would need more information.
Yeah.
Yeah, I would know. I know those rules that if a veteran's on Social Security or at the pension age and all that, and they meet the income thresholds and they have a period of war, VA will award pension pretty easily. But I'm thinking that's probably not what you're asking. And we don't really do pension cases that much, so I would doubt that's what you mean. I don't
Gary,
know. Yeah.
I think you might be onto something. I did practice Social Security for years, and there is a 55. I mean, there's a regulation with Social Security that changes the way that cases are evaluated at 55 years old, when you're determining disability for the Social Security Administration. I don't
Mhm.
know if that's what's being asked here, but I will clarify if anyone is wondering that regulation that assists claimants with Social Security over the age of 55, that does not apply with the VA. And so, just like Kerry said, unfortunately, being over the age of 55 is not necessarily going to assist you in an IU claim. You would, still have to meet all of the other requirements as anyone else. It will assist you with Social Security, but unfortunately, not with VA.
Michelle Torado, part one. During exam for, I'm guessing legs or lungs, uh, fibromyalgia, knees, hips, neck, shoulders, uh,
Cramping.
experienced severe cramping
Mhm.
and PN, probably peripheral neuropathy from foot to back, making it difficult to stand or lay down. So I stood. Nurse barely reviewed forms. Uh,
Maybe.
I filled out the night before, spent 8 hours completing. She spent most of time typing and accessing records. I barely spoke. Pain so severe. I only completed shoulder and neck portions while standing. Nurse advised stopping exam after an hour and a half, or
Mm.
I guess that's an hour and a half, because didn't want to cause me more peripheral neuropathy, more pain. Gave forms to me. Should I be concerned about not completing exam? Should I submit forms? What should I do next? Can I mention other pending claims, example, lung bronchiectasis, and how it affects my life when going for TDIU exam, or just stick to my PTSD? There's a lot there. I don't know if all those things are service connected. I can probably taking the easier question first. You can talk about any service connected condition when going for a TDIU exam, as long as it's service connected. If it's not service connected, I probably wouldn't raise it, because VA can only consider what is service connected. Even if it's a claim pending for service connection and it's not service connected yet, VA cannot consider it for TDIU claims. As far as the exam, that's a really big, in my opinion. It depends. Uh, the examiner may have been able to complete those exams to your favor. You really need to get a copy of them and look at them. Um, you can always write a letter to VA explaining what happened in the exam process, in case they're incomplete or something. A VA employee could see that, maybe request new ones. But yeah, I'm sure I'm not answering part of the question. Shelly, do you have any insight there?
No, I think I was thinking the same, Carrie, just that it's unfortunate. And I know Carrie and I both hear these stories, unfortunately, frequently from our clients about how the exams are just not thorough, or they're not evaluating things correctly, or giving you guys opportunities to actually talk about what's going on. And we don't have a lot of recourse there. We, like Kerry said, you can write it down and you can submit that to the VA as a complaint. You can raise it in an appeal if you, like he said, if you get a decision and you read on there that they're saying the examiner gave a unfavorable opinion, or you get a copy of the examination and you see that the examiner didn't put anything that you said in the report, or that it's just inaccurate, you can certainly raise that in a future appeal as an inadequate exam as well. But unfortunately, I feel like, raising the complaint on the exam and then just continuing to pursue the underlying issues is probably the best thing to do, unfortunately.
Yeah. All right, Grace Smith regarding 2-page TERA memo, evidence of exposure, include the subject and date of receipt of the cited documents. Where are they getting these documents, and explain where VBMS folder Persian Gulf War section 117 flash in memo. Where do they get this info for TERA memo? Explain what's difference is there evidence of record location explain. I'm not sure what you're asking here. We can find this info ourselves. And who is completing this memo? CMP examiner. Yeah, you want to start that off, Shelly, or you want me to?
I'll give it a shot. I think they're asking who's completing or who's requesting and completing the TERA memo.
That's
And
what I think they're asking too. Yeah.
yeah, that's not the examiner. So that's being done by the whoever they're researching and working the claim up. I don't know if you call it an adjudicator, Kerry, or whoever is working the claim at that time.
Yeah, rating RBSR. I'm sorry, a BSR, Veteran
Yeah.
Service Representative.
So they're going through your file, they're going through the personnel records, they're pulling out anything that any deployments, exposures, anything like that that needs to be included on that TERA memo, and that's where the TERA memo is coming from. As far as being able to provide evidence, you're always able to provide evidence, as unless you filed a higher level review. So if you have evidence of an exposure or anything like that that you feel is not represented on the TERA memo, or that they're not addressing, absolutely submit that. I don't believe that you can be involved in their completion of the TERA memo, but you can certainly submit evidence if you disagree or you think that there's something left off of it.
Now, I will add, because you mentioned section 1117 and 1119. What you're talking about there is basically the Gulf, the Gulf War. 1117 is Gulf War I, in other words, 1990, 1991. 1119 is Iraq and Afghanistan, burn pits, and all that stuff. So if you qualify for one of those, they would be getting some of that information from an ILR, an individual longitudinal exposure record, and that's a DoD document. VA or DoD started tracking exposures, and I use that term lightly. A number of years ago, they weren't really tracking them in Gulf War I, but they've somehow backfilled their information. So they will give this ILR report to VA, and VA will use it to some respects to fill out the TERA memo. I wouldn't put a lot of weight on it. Okay. It's supposed to be, and I'll give you an example. I think we've said this before in other videos. So you might want to go watch. I think I did one a few weeks back that's just on this, partly on this subject. For example, Gulf War I, all the oil well fires and a bunch of other stuff that happened in 1990 and 91 certainly exposed people to benzene, among other things. The ILA report will address benzene, and they will give a cancer risk and a non-cancer risk for disabilities. And their cancer risk is a number that has a decimal point and about 9 zeros in front of it, and then 2 6. It's such a small number, they had to come up with like an algebraic way to express the number rather than writing out all those zeros. It is minute, all right, and they do that for every single ILR, for every single veteran who gets an ILR, regardless if that veteran served right in between all the burning oil wells or 100 miles from the burning oil wells, if they served there a day or 6 months. If they weren't burning for, I don't think they were burning for 6 months. But the point is, it's the same number for every single ILR for Gulf War vets. It's ridiculous. It does still concede exposure to benzene, but you just can't rely on their level of exposure. It's kind of ridiculous. So, but yeah, you're going to get some of VA get some of that information from those ILRs for Iraq, Afghanistan, Gulf War vets, things like that. Other than that, they get it from your MOS and wherever else they can find it. Hopefully stuff that you've given them, but we see that all the time where we give them exposure information and it doesn't end up on the ILR. Or I'm sorry, on the TERA memo. So hopefully I didn't confuse you too much there.
No, that's good. No, that's good information. Thank you.
Alan, what can you do if after you submit your claim, VA is asking for more evidence that you don't have? You just got to yeah. You just tell them. You tell them what evidence you have and what evidence you don't have. They're going to ask you. They're sometimes going to send the same letters out and ask for stuff you've already given them. Giving them the best you can. You can write a letter to them in response. They can't, refuse to decide your claim because of that.
Yeah, I agree, Kerry. It's constant that we're receiving letters asking us for information that we've already submitted. Number one,
Mhm.
we always respond with a letter saying we submitted that. Here's the date. Please process the claim. And then if it's something that you don't have, then you can't submit. You can respond to it and say, I don't have this information, or that it's your duty to find this information. But um, one of the big things I would highlight is that we just get all the time, we get constant communication from our clients, frustration over these letters saying that we haven't submitted things when we have. And so just kind of expect that, and just respond to them and tell them that you have, and hopefully and eventually they will process it properly. But unfortunately, it is a very common occurrence for us to see those notifications telling us we have not submitted something when it's clearly been submitted and we can tell that it's already in the file.
Roger Smith. My wife was an Army nurse in Vietnam between 69 and 70. Developed sarcoidosis around 1980. Followed at National NIH, which is National Institutes of Health. Might have come back now. I read that it might be caused by AO. Any thoughts? Thanks from a Vietnam veteran. You want to take that, Shelly? You want me to give it a shot?
I can start off. You jump in. I think that it's. I'm not a doctor. It's not a presumptive condition, but it's definitely something to look into. I think with a federal medical nexus opinion, you could prove the claim. I think it's something to have somebody take a look at and see if they can make a connection there for her.
Yeah, no, I agree. Sarcoidosis it's an elusive animal. If you Google it and look at the more respected documents on it, like from NIH. You're going to find things, people saying, well, we don't know what causes it, to we think it's caused from some pathogen, maybe from some environmental exposure. So there's a gamut of things, that could cause it, it appears. And for that reason, I would certainly pursue it in a claim. It can be very mild in some people and exceptionally severe in others. And a lot of times I think, if somebody knows your history, Vietnam service, working as a nurse, well, what are you going to have there? You're going to have Agent Orange exposure, but I would not rely on that alone. I have not seen many in relation to that. But you're going to have all the exposures a medical professional in a combat zone is going to be exposed to. It could be tons of pathogens. All the endemic things just in that area of the world. And so, there's probably a number of things that a doctor could link that to. It just has to rise to the benefit of the doubt level. So I would certainly go for it. Shimp Howard, good afternoon. I requested code sheet, still waiting for it, but at 55, just got mental health rating. Should I expect routine exam in future, or RE exam in future? It's not enough information there, in my opinion, to answer that. I would not say just because you are 55 that you're not going to get a future exam. Obviously, the code sheet would tell you. If there's a future exam dated on there, you would know it. And I don't know what rating you are, but let's say you're 100%. Did they award dependents educational assistance, Chapter 35 benefits? If they did, that means they're not going to re-examine you again, because you have to be permanent total to get that. If you're rated 10% or 30%, the odds of them doing a future exam at that level is really small. But if you're rated, 70%, or it could go a lot of ways. So just not enough information for me to answer it. Or Shelly, you might have something there.
I don't think I have anything to add. I think that may be a clue on our earlier question about the 55 rule. That seems to be a common occurrence, but no, I agree. I don't think, unfortunately, that just because you're 55, there's any impact on whether there's a permanent and total classification and with future exams or anything like that. I would definitely get the code sheet and go from there.
Yeah. Zeb Moultrie, good afternoon. If BVA remands a decision, does it go back to the end of the line for the AMA lane? Good question. So it kind of depends on where you are in this process. So if you've appealed an AMA decision to the board and they remand it, and that's where you are right now, that it's not really a back of the line thing at that point, because it's back at the, I would say, local office. It's not really the local office that works it. It's the Decision Review Operations Center, which is a regional office, just may not be the one that where you live. There's a number of them. There's one in DC, one in St. Pete, one in Seattle. They work all appeals. It will usually go to one of those offices. They work it in date order. Unfortunately, they use the date of the board decision remanding it. So when it's all a shell game, all right, how they do this. But let's just say you waited for your remand to get worked up for 6 months or a year or whatever it may take, and they deny the case again, and you have to appeal back to the Board of Veterans Appeals. Unfortunately, in that circumstance, you do get a brand new docket number from the Board of Veterans Appeals. and you are at the back of the line. I cannot stand it. I am rather emotional about it, or let's just say excited about it, because when the AMA was passed, the board did not have to change that rule. In other words, in the legacy process, when a remand went back to the board, which it did automatically if the regional office didn't grant the benefit, you kept your old docket number, so it resumed its place in line. So on remand, you wouldn't wait that long. The AMA got passed. It did not address that part of the appeal process, but the Board of Veterans Appeals went forth anyway and changed that rule. It was underhanded. They didn't need to do it. It was the exact opposite of the intent of the AMA that passed in the first place. You should write your congressman. You should write the chairman of the Board of Veterans Appeals, and everybody should complain about it because it's BS. It should not have been changed. In my opinion, the board was expressly trying to dissuade people from appealing back to them in their quest to make their life a little easier, but the AMA didn't do that. So there you've got my somewhat heartfelt opinion of it. Well, while you're at the local office, and I said earlier, it's kind of a shell game. You know, they go off the date of the remand to work it. So if it, and the reason I say it's a shell game, if it took your case 6 years to get to that point, and and the board did its first remand 6 months ago, and that remand has a date of claim on it, it's the date of claim of the remand. So when it's everything in segments, okay, instead of one long appeal anymore, every little thing is in segments, so they can look at the board remands, and yeah, they can get an accurate assessment of how long it's taken them based on their dates of claims and all that. But what it's not telling them is you might be having some very old cases, been on appeal for 5, 10, 15 years, and you're treating it like one that's been on appeal for 3 years, simply because you're using a date of claim that's equal to the board decision date. You know, and they're still going to work those in that date order. But yeah, it's frustrating. You know, and VA will, you know, they'll play with those numbers any way they can. Anyway, that's I should probably get off that soapbox. Shelly, do you have anything to add to that?
Let's see. What is it? Back. So yeah, like Kerry said, that it doesn't go back to the end of the line, so to speak, but it does go by the remand date. And also be aware of what the remand's requesting. Are they requesting a CMP exam? Are they requesting additional records? What is the workup that the board, if any, is sending it back down for? And so, you know, if you know that they've requested a new CMP exam and you haven't been set for a CMP exam, then be, you know, looking for that. And if you are your own advocate and you see that there were records requested, or they're asking for private medical records, or whatever it is, that's the development that's going to be or should be completed at the regional office. And so the time it takes for them to make a decision could depend on what they're remanding for and what development is needed. Of course, if there's anything that you have that you can submit or get to the regional office to kind of cut down the time that they require for any development, that may help you get a decision more quickly. Okay. You want me to do this one, Kerry?
Yeah,
I
I'm
can do
sorry.
it. Oh, you're good. I'll try. Sorry.
Richard, at one of my CMP exams, I was advised that I do not have a TBI. They were saying I have pseudo dementia. They advised no CT will be done to confirm this diagnosis. Is there a way to force them to give me a CT to confirm if I have a TBI or pseudo dementia? I'm only 40 years old and having a hard time believing that I have dementia. Very good question. In my opinion here, if you're, and I hate to say this, but if you're limiting that to the CMP exam process, then I would say no, you can't force them to give you a CT scan, not during the CMP process, because the VA has to ask for that as part of the claims process. I don't think I hardly ever see them do that. But in the examination and request process, globally speaking, they have discretion. So much so that it gets under our skin all the time. And so to force them to do one as part of the CMP exam process, you might have a hard time. But if you take those same results to your VA care provider, they might be able to set you up a CT scan just as part of your regular health care. And then you can use that evidence in your claim at that point, or take that, if you have a private doctor, do the same thing, take that to your private doctor. Shelly, you got any better advice than that?
No, that's exactly what I was going to say, is that you're probably not going to be able to force them, but hopefully you have either or VA healthcare or private medical treatment to where you can see one of your doctors and have them do whatever testing it is that's needed. And then you can submit that evidence and kind of push the VA as far as your compensation claim that way with your own evidence. Okay.
Jess Swope, are the failure to assist still stacking up and no one making a decision? So I'm assuming you want to take that one, Shelly? I think you're talking about duty to assist errors.
That's what I'm thinking. This is kind of the same. Well, I mean, I'd say in general, again, this can come down to what was the duty to assist there, what's the reasoning for it, and what's the development that's needed. What is it that the regional office is doing? Are they requesting records, examinations? Are they actively pursuing those things, or did the claim get stuck somewhere? I don't know, time frame wise, I would say, I mean, again, if you're 6 months, a year after a duty to assist error has been issued and you haven't received anything as far as an exam or notification that they're asking one of those letters asking you for evidence or a decision or something, I would start calling or writing letters or asking for some kind of update. Do you think, Kerry?
Yeah, I mean, it could be a number of things. If it's something to do with this, I'll just start plucking some things out of the air here. Surviving spouse, right? Work cases worked at the PMC. Those take an insanely long time compared to other claims. If you're a VA employee or a relative of one of your cases in St. Paul at what's called the RAC, where all employee files are, those take an insanely long time, regardless of what you're talking about, duty to assist error or anything else. If something's been returned on duty to assist error, like from an HLR or the board or something like that, we see cases all the time where the end product just disappears. Somebody cancels it, or what more often happens, they fail to establish it. Not saying that I mean, that's kind of rare, but it's not uncommon. And that would, if VA didn't know that it had dropped that end product, it's an electronic code that controls that case, then yeah, you might not hear anything of it forever, right. Unless you got their attention. So there's a number of things that could happen to affect that, as long as it's pending and it's pending. I agree with Shelly. I have seen these starting to tick up in their time frame, and it seems to be different for different type. A lot of it what kind of development is it going to require? Is it going to require VA to go out and verify exposure issues, or do they have to get an exam, or some development's going to take longer than others? There's a whole lot of development that needs to be done. I mean, a lot of things could affect that. I have been seeing it tick up, but I do also see them develop these claims on a regular basis. So I can't say they're not making decisions on them. They are. It's just, different rhymes or reason for different types of claims taking longer than others. It's hard to say.
Yeah.
Um,
All right, Kerry, unfortunately, I think this next is going to be our last question today.
Okay.
And
All
okay.
right. Timothy Cohen, conduct my higher level review. This is this morning. I want to say, thank you, the team at Hill and Ponton, for the great advice. The adjudicator agreed that I should have received a higher rating based on my bilateral foot drop, and that she would go back and review my claim file, and I should receive an update within a few days. HLR do work if you have the evidence in a claim file to fight it with. Okay, I say HLRs do work if you have the evidence in the claims file to fight it with. Yes, HLRs can work, and I'm glad our advice was able to help.
Mhm.
Yeah, if you've got bilateral foot drop, if it's complete foot drop, that to me, I would argue for loss of use of both feet on that. Just saying.
That's wonderful. Great news. Great job being an advocate for yourself. We're super glad that we can provide the information that assisted you with that appeal. That's great. That's a great way to end, right, Gary?
Yep, I like it. And sorry we didn't get to all the questions.
Yeah.
I know we rarely do. I don't think we ever do. It's a whole lot of questions, but we will be back probably in a week and doing it all over again. We
Sounds
might
great.
not, but
We'll be back soon.
yeah.
Thank you guys for joining us. Have a great afternoon.